trial in C-2008-5016. Counsel, please announce your appearances for the record.
Ronna Fickbohm on behalf of Pima County, Your Honor.
Bill Risner on behalf of the Libertarian Party, together with Ralph and Bill John.
And John Richardson on behalf of Beth Ford.
Good afternoon, everyone. All right, you've got me until 3. Mr. Risner, the floor is yours, sir.
Thank you, James. I wrote a date on the board. It's September 12th, 2008, almost 4 years ago. The Libertarian Party and then later the Democratic Party joined in and alleged that there was substantial evidence that an election had been rigged, the ballots were inexistent, and that we wanted to show that that election had been rigged, and we wanted perspective relief. We wanted in the future an order that would prevent cheating. We recognize that it is all about the right and the ability of the county to cheat in the future. I want to put up on the board something that is in a memorandum, but I want to explain what these statements mean. This is a database case, and this was the opening argument of the county. And Chris Straub says, we know that databases aren't secure. They can be altered using Microsoft Access. And they can be easily manipulated. And he says the bottom line is we're only going to catch stupid people, all right, because one could also alter the audit logs, one could do anything. So one of the problems that I see in this case is we have the county coming in, and they frighten the court by saying, whoa, this is the RTA, and if we permit evidence that that election was rigged, that's what John Richardson argued. Then what about the board? What about the legitimacy of this organization, so forth and so on? And therefore, you can hear no evidence. And of course, because you can hear no evidence, you also don't understand how many ways they can cheat or how the system works. So let me give you an example. There's an election coming up, which the Board of Supervisors will run. These defendants that we have evidence that says that they rigged an election on their instruction. Okay, this election's coming up, and we've offered some, it's part of the disclosure statement that's in the record where Brad Nelson talked about how the last election, I think, there was 45% of the votes were early ballots. I saw an article in the paper this week that talked about because of the effectiveness of the permanent early voting list, what they call PEVL, that they expect, I don't know, it's like 60 or 70% of the ballots to be early ballots. So here's what happened. We have 409, I think, precincts in Pima County. All those early ballots come in, and they're not segregated by precinct. They count them. They go in, and they'll take a stack. They'll count 300 ballots, 200, 400, just by stacks. And there will be a total. But there's no auditing anywhere of any of those early ballots. So the system we have is built on a Microsoft Access base, and it can be altered using that. there's evidence and other evidence in court testified in the database case about our election, our one guy that runs the computer, taking home with him a copy of the CD of the database. But he didn't have to take it home. He can come in the office. And he can take that CD, change those vote totals. And because the database and the audit log is part of the database, then he can just erase on the audit log whatever the changes were. And he can put the numbers any way he wants. And there's no auditing. You might say, well, there's some auditing at the precinct level. And the 30 or 40% that are there, some precincts, in fact, are randomly chosen where there's an audit of some races, but no county races, no bond races. None of those are ever audited anywhere in the system. So when Your Honor issues an order that says the most I can do is to tell them to behave, to tell them to obey the law, you can issue an order that says segregate the early ballots by precinct. When you do that, you can have auditing by precincts. And because the ultimate statement of voters cast, the canvass, would have a number that can be compared with another number. And why is that important at this stage? At this stage, we're talking in Rule 59 about showing the court where you made an error of law. Now, we know that the Pima County Superior Court made a large error of law when Judge Harrington heard the case, because he ruled that the court system, the Pima County court system, had no jurisdiction. At the urging of Pima County, he ruled there was no jurisdiction. That you can't come in. This courthouse is closed. Even though he and this court, everybody agrees that we have to assume the proof of our allegations. It's the rules that we all operate under. We have to assume that Pima County did rig that election, because that's what we've alleged, and we're being denied the right to prove it. We have to accept that they did it. And who did it? We have evidence that it was on the instruction of the bosses. They had one operator who was involved with rigging the election. There's many ways to do that. But we're being denied the opportunity to put on evidence to prove it. The courthouse door has been closed for 4 years. September 2008, we made that allegation. And every year, there's elections coming up and coming up, and I think there's a feeling that I sense from courts that say, well, gee, I hate to get involved with this because an election's coming up. But you need to be involved with it because there's always an election, and there's nothing more important. And if we are unable to prove in court, unable to put on evidence, unable to show the court the various orders that could be instituted, we're being denied what is absolutely the most fundamental part of what the court system is here for. I was reading your ruling just before this court hearing. There was a statement in there, and I don't know where it came from. It said that, well, the election procedures are exclusively the province of the executive branch. Well, clearly that's not the case. Primarily It's the province of the legislature, but the courts have a role. And what we're seeing here is, if Your Honor would look at the panoply of our election procedures in this state, a whole bunch of them are when paper ballots was counted at the precinct. A bunch of them are when we used machines where you pull levers. And now we use computers. And sure, the legislature has a major role. And in fact, what have they determined about running elections? They've said the Board of Supervisors run elections. The very people that we allege through their management has rigged an election are the ones that run it. But the courts have a role. Sure, the executive does have a role. But in Arizona, the executive, through at least the Secretary of State, has a very limited role. I've offered, and we have evidence. It's Your Honor talked about the disclosure statement. There's a statement in there from the Joe Kingfield on behalf of the Office of the Secretary of State saying that he can't look and see what goes on in any computer. They can tell the county what to do to protect the computer, the hard physical computer, but they can't even look to see that the county is obeying. It's not there. So yeah, different parts have a different role. But the court has a huge role, because in the Constitution, the court says elections have to be free and fair, and in the Constitution, it's the courts that ensure that those things happen. And yet, the Pima County Superior Court has bought every argument that the county has given, and for 4 years, they've not been required to file an answer. For 4 years, no evidence has been permitted to be offered. And this is what we prayed for in our complaint. And we want an appropriate permanent injunction is what we've asked for. Your Honor has said, well, gee, the county says you can't do graphic scanning, which is something that we would ultimately urge, just like we would urge that precincts be segregated. We would urge that a higher percentage of auditing. There's a number of steps of things, a variety of steps of what this court can order so that the public will know that the court cares, the public will know that the election results are honest and correct results. And don't forget, this is a case where the county has already lied to this court. Remember, we were in here and the county sought an emergency hearing because the lawyer for the Libertarians wouldn't agree to change something. And yet, it was in writing, right by an email that they deleted that we agreed. It's the county who we allege has cheated in these things and can do it again and can never be caught. And we will be very happy to prove every single one of those elements. They're the ones that say, hey, no, the most you can do is just tell us to behave, and you can't do that, so why bother hearing this? Why bother should we put in an answer? Because, heck, they've only alleged that we rigged one $2 billion election. They've only alleged that we systematically perverted democracy in Pima County, but they've not alleged that they have a good faith belief that we would do it again. The whole point of this lawsuit is to keep them from doing it again. The whole point is to look at election procedures and say, how can we prevent them from cheating? How can we protect democracy? That's what this court's here for. That's what I'm here for. That's the oath that we all took, is to protect the Arizona Constitution, protect the right of the people of this county and this state. This is very important. And for 4 years, The Pima County Superior Court has kept the door locked, has not required an answer, and has said you can't step forward and you can't proceed, and yet there's elections every single year. This court has made a mistake. The point of a motion for a new trial is to give you the opportunity to correct the errors that the court has made. Thank you.
Well, Ms. Fickbohm?
Thank you, Your Honor. I guess since that allegation of lying was obviously directed at me, I just have to start out by saying I disagree with that characterization of anything I've done in this case. I also disagree with the characterization of Judge Harrington's prior ruling that this court has no jurisdiction, because I think the implication being that that's something the Court of Appeals has addressed. Judge Harrington read the Liberton Party's second amended counterclaim is either stating a request for assistance with a criminal prosecution or an election challenge, and said, I don't have jurisdiction to do the first because that's what the prosecutor's office does, and with regard to the second, you're time barred. That's all that Judge Harrington decided. I also object to this continuing characterization of that we have to accept the fact that Pima County agreed to a $2 billion bond election. What the Libertarian Party, at the time it was Mr. Ellenwood, only not Mr. Risner, alleged in the second amended complaint was that there was substantial evidence of election fraud. Wisely, counsel didn't say that they knew that election fraud had existed, and in fact, as an exhibit to the second amended counterclaim, they attached Mr. Risner's very long July 14, 2008 letter to Terry Goddard, our Attorney General, in which Mr. Risner goes through in detail why he thinks Mr. Goddard should be taking a hard look at this election, and in which he concludes by saying the obligation to determine a crime has occurred is not for the Democratic Party, and says whether or not a crime has occurred can simply and definitively be determined through an examination of the ballots. We ask for you to personally direct that the current investigation be conducted in such a manner. Elsewhere in the letter, he asks for a hand count, which is all a matter of record in this case. The Attorney General's office did, and which they determined there wasn't sufficient evidence of fraud to proceed upon. In the second amended counterclaim, also at paragraph 7, it's alleged that tampering with ballots is a crime. And in fact, everyone acknowledges that's true. And one of the statutes they cite is ARS 161016, which basically says someone is guilty of a Class 5 felony if they knowingly change a ballot after it's been entered. If you really have evidence of a person going out and changing hundreds, thousands of ballots, that's a lot of Class 5 felonies. So when it's suggested to you that unless you step in and do that, which Mr. Risner has yet to identify any law saying that you have jurisdiction to do, unless you step in and put in place new election procedures, this is a system that's unchecked. It's simply not true. I read you just one of the criminal statutes, but in fact, in the second amended counterclaim of paragraph 7, they cite a series of Title 16 statutes making a crime a variety of voting offenses. And the bottom line here is everyone agrees that voting is sacrosanct. Everyone agrees that elections should be pure and evidence the people's will. But if the Libertarian Party wants to put new election procedures into place, they need to go to the legislature or the Secretary of State. And I think when we've been talking about the executive branch, that's been the Secretary of State as being part of the executive branch as opposed to the legislative branch. Once again, we have Mr. Straub's out-of-context statements paraded in front of you for effect.
Here's where we have much agreement, surprisingly. And this, in some sense, may make the trial either shorter, or at least when you go to unravel everything that we said, you'll have some real easy basis upon which to draw some conclusions. There is no question that there are significant flaws with the GEMS software from a security standpoint, not from an accuracy standpoint, from a security standpoint. Second, the databases themselves are not secure. We know that. And we agree that they can be altered using Microsoft Access. We know that these databases are essential for programming the memory cards of the machines. Why anybody would want to have this kind of insecure software out in the public domain, however, is something that is beyond us. We don't understand, I mean, certainly we understand a need for transparency, but surely there must be a balance for security as well. And the problem here that we have, and I don't think there's any disagreement about this among the experts in some sense, is that, gee, if this software is really that vulnerable, we should get a new system that merits getting this. And our point is, again, that this data that they are seeking, however, will have very little value for the purpose for which he has said he wants it. Because it can be easily manipulated, the bottom line is, in this whole thing, is we're only going to catch stupid people, all right? Because one could also alter the audit logs, one could do anything. So we could give them a database if somehow we were corrupt. You know, these things are always amazing to me. I don't understand how we can be simultaneously Machiavellian and stupid at the same time, but I guess there is a possibility. Judge, this case is not about what should happen with respect to the machines that we have or anything, because those same experts will tell you right now there is no commercially available machine that is certified. No commercially available machine and software that is certified for use in Arizona that does not have some of these computer security flaws. It's just the error.
I would like to remind the court that that was an action under which the Democratic Party sought to get a certain computer database. And Mr. Straub's concerns, when taken in context, were that if you took this database outside of a closed and secure system, the security measures that Pima County had in place to protect that database would be lost. And that's where the danger lied. It was not a wholehearted confession by him that the procedures that have been approved by the Secretary of State, approved by the legislature, somehow constitute an insecure system. I was glad to hear Mr. Risner acknowledge that their disclosure statement is part of the record, because that seemed to have been a point of contention between he and I, so I'm glad that that's resolved. The suggestion to you today, I've heard a new suggestion, is that you can issue an order, an injunction, saying that the ballots have to be segregated and then audited in a particular way. In my briefing, I pointed out that there are certain auditing provisions already in place as a result of Title 16, and it's not the place for the court to go in and say, I'm going to come up with different procedures than the legislature has already put in place in an area that the legislature has chosen to act. You know, the bottom line with regard to the motion for a new trial is the Libertarian Party doesn't seem to disagree that they want you to craft new voter laws. And they haven't provided you with a single legal citation showing that you have the ability, any court has the ability, to craft a new voter law. The Libertarian Party doesn't explain by pointing to the specific paragraphs of the Second Amended Counterclaim how that states an actionable claim for injunction, as pled. They don't disagree that Pima County has made significant changes to its election procedures after the May 2006 special election. You'll notice in arguing this motion for a new trial, in general, they were very careful to say, well, the same employees are all there. They don't say to you all the same procedures are in place. I attached as an exhibit to the reply in support of my motion to dismiss as Exhibit F, the December 18, 2007 under advisement ruling in the database action, which includes statements by Judge Miller there talking about how the Democratic Party has been instrumental in getting Pima County to put new election procedures into place. I provided other evidence to you that's a matter of public record that the Elections Integrity Committee has been put into place. They can't come to you and say everything is the same as it was in 2016. It simply isn't. They don't tell us how their arguments today fit in the Rule 59 framework. They have to prove, part of their burden of proof is of showing fundamental error that materially affected their rights. And I know that they vigorously disagree with Pima County's argument and with your ruling that you don't have jurisdiction to make new voter laws. But to the extent that they want to quibble with that, that's a motion for reconsideration. That's not a motion for a new trial. A motion for a new trial is how was there some error that materially and fundamentally affected their rights. They had the opportunity, continuing through today, and in their motion, to come forward and say, Judge, here's a case that says, even if the legislature has acted to make voter laws, even if the Secretary of State has issued all of these regulations, the court, the judicial branch of government still can step in and add new laws to that. They haven't offered you a single law. They keep saying, we just want, how do they put it? They put it, an appropriate permanent injunction to prevent a reoccurrence. Well, they've had lots and lots of time to come forward and tell you what that injunction is. And the best statement that we have of that is what they disclosed in their disclosure statement that they filed with this court on January 12, 2012 in connection with the reply in support of their motion for a court order directing Iron Mountain to secure the ballot boxes. And there they told you that they want you to order graphic scanning, that that's what they're going to ask for. So it's no surprise that you took that into consideration in your ruling. If they have a different permanent injunction, if they think that you have the ability to enter, the time to come forward and say that was in their motion for a new trial so that I would have the chance to look at it and respond as to whether or not the court might have jurisdiction. The one case that they've cited for the proposition that you do have jurisdiction to enter an injunction is the Barrett versus Voss case, the 142 Aries 489. And that was a very particular type of case. That was where someone got his name on the ballot for to be a member of the Arizona State House of Representatives, basically making a false statement that he'd been a continuous Arizona resident for 25 years. And there was a specific statute, ARS 16351, that allowed a legal action to be brought by a voter within that area to challenge that person's name being on the ballot. And previously, the Arizona courts had clarified that the action allowed by that statute was by way of injunctive relief. But that's a very specific injunction that says this person doesn't meet the qualifications, I order you to take their name off the ballot. And that's been established by case law and by Arizona statutes. They've had the opportunity to come forward in their motion for a new trial and identify for you any law demonstrating that you committed a fundamental error of law, or to identify how it is their Second Amendment counterclaim states an actionable claim as pled, and they haven't done that. They would rather focus on the issue of are elections important? Yes, elections are important. Everyone agrees with that. But that is not really the issue here. Your Honor, I would ask that you state that you've considered everything that they offered in connection with their motion for a new trial, and reissue or hold your order as originally issued, which was correct under their second amended counterclaim was pled, and was correct under the record in this matter, which includes the disclosure statement that they offered to you on January 12th of this year, that Mr. Risner has now acknowledged as part of this record, and that was correct under the law as cited by the parties. Thank you.
Thank you. Mr. Risner. Judge?
The legal case that I rely on is Bedford and Republican Party and Pima County Libertarian Party, the memorandum of opinion in this case. Our Court of Appeals, in this case, said this court has jurisdiction. It said, in its counterclaim, the Libertarian Party alleged there was substantial evidence of tampering by Pima County election employees in the RTO election, asserted it was entitled to an injunction prohibiting such tampering in future elections. It also requested to examine the ballot, time for discovery, a hearing for whether the ballot tampering had occurred, which would necessitate a permanent injunction of such actions in the future. It goes on. Thus, although the Libertarian Party might be required to show there had been fraud, any finding would merely be incidental to the court's determination of whether to grant the injunctive relief, so forth. So the Court of Appeals didn't say, oh, we've looked at this and the court can't issue anything. This is all the legislation. This opinion has an entire section on separation of powers. This is Groundhog Day movie once again. They're arguing what the Court of Appeals has already determined. And in what case do you come in and before they have to file an answer, before there's evidence saying, I want the detailed hearing on what you want in an injunction? Is that anywhere in our legal procedures? If it is, would you give us a few days of court time? And we'll give you details of what needs to be done. But there's an orderly process in all court pleadings where we make pleadings, we ask for relief, we do just that we come in and tell them here's the kind of relief we want. We put on evidence of why that relief's necessary, how to accomplish it. It's a very complicated thing, and the court considers alternatives and ultimately issues an order or doesn't issue an order or a different order. That's the way it goes. But what's happened so far in this case for 4 years is an answer's not been required. The courthouse door's been shut, and absolutely there's not been a permission for even to put on evidence, not the ability to show the possible orders that can be. And that's simply wrong. It's fundamentally wrong. And this is the point when that needs to be corrected and not kick the can down the road for another year in the Court of Appeals, another year in the Supreme Court. But how did 4 years go by? 4 years go by because they sold a bill of goods to the court, telling this court it had no jurisdiction. And back, here we are again, and they're running the same arguments. Thank you.
Thank you, folks. I will consider the arguments presented this date along with the motions submitted and the record filed and take the matter under advisement and rolling out to you just as quickly as I can. With that, we stand adjourned. Thank you.
Taking the number of